Well, hello everyone, and welcome back to Uncivil Law, where we learn through the misfortunes of others. I am your host, Uncivil Law, a licensed attorney in Texas, Virginia, and before the United States Supreme Court, and I hope you're having a fantastic day. We are here with our legal news roundup, all the legal news happening in your world so that you might be better legally informed. Let us begin with our good friend, Sam Bankman-Fried is back in the news, and sadly will only get one additional day to meet in court with his lawyers. Sam Bankman-Fried filed a motion with the court asking to meet with his lawyers every single day. 5 days a week he wanted to meet with them in the offices of the U.S. Attorney, in their proffer rooms. That's the room where, you have meetings to discuss possible plea deals, for example. It's large conference rooms, basically. He wanted to be able to not be in jail and rather meet in the offices of the U.S. Attorney and use their space, and wanted to be there every single day and not be in jail and have access to a computer with the internet and all the rest of it. And the judge is over here like, how about not? How about instead of every single day with 2 computers and 2 Wi-Fi, how about I give you about 6 hours of access, and your counsel has a laptop, and that's all you get. So Sam Bankman-Fried, is in prison now because he effed around, and so he got violated on his bond and bail, and now he's like, oh, I don't really like being in jail very much. It's like, yeah, suck it up. So let's learn a little bit more about this. The federal judge who is overseeing the FTX Sam Bankman-Fried case has issued an order allowing Sam Bankman-Fried to meet with his legal term outside of jail for about 7 hours, from 9 o'clock until 3:30 in the afternoon. So that's nice. In the August 21 filing of the U.S. District Court, the judge, Lewis Kaplan, who I think is losing all possible patience for Sam Bankman-Fried, ruled that Sam Bankman-Fried will be allowed to meet with his counsel in the cell block attorney room at the courthouse on August 22nd regarding one of his scheduled hearings. So it's like, okay, you're already going to be here for a hearing anyway in the courthouse. So sure, you can stay in the courthouse for a few extra hours and meet with your attorneys in one of the rooms at the courthouse, and you can have a little chat with them there. And then, that's all you get. So fun and exciting. This is what happened, of course, once you have your bail revoked. Because, when you were out and about and, just living at your palatial mansion on house arrest, you could meet with your attorneys anytime you wanted. They could come over, you could have a little chat, maybe a little sandwiches, a little tea, it'd be fun. But now, how about not so much? How about you get to spend your time in the Metropolitan Detention Center in Brooklyn, like a common criminal? How very sad. And you don't get access to a laptop or a computer inside the MDC. How very sad for you. So this is what happened when you effed around. You were out and about, and then you decided to try to interfere with witnesses, and now you don't get as much stuff. So guess who that's on? That would be on you. According to the order, Sam Bankman-Fried will be allowed access to one internet-enabled laptop and one Wi-Fi device from roughly 8:30 in the morning until 3:30. I thought it was 9 till 3:30, but either way, while meeting with his counsel. His lawyers had petitioned the court for more, asking that Sam Bankman-Fried be released 5 days a week to meet with them for like 8 hours a day in the U.S. Attorney's Office. However, the judge said, how about not so much? How about instead of every single day, how about a one-time thing? And this is all you get because you effed around and now you're finding out. So, no, you can't have those things. Not for you. Sam Bankman-Fried's first of 2 trials is currently scheduled to begin October the 2nd, and it seems like the judge is actually interested in maybe trying to actually meet that deadline. So the judge seems interested in trying to push this thing along, because the judge, I think, has lost all patience with Sam Bankman-Fried and his many antics. So the judge is like, okay, how about that speedy trial? How about I'll insist on your right to a speedy trial? How about you will get your right to a speedy trial whether you want it or not? We're going to do this thing. Yeah, how about that? So he's going to face 7 charges in relation to the fraud at the FTX. The latest superseding indictment filed by prosecutors say that they will consider SBF's alleged violations of his finance scheme as part of the wire fraud charge. So they had charged him with campaign finance violations separately, but those were dismissed due to a potential screw up, whether it was deliberate or not, with how they did the extradition with Jamaica, because he was in Jamaica at the time. And we do have an extradition treaty with Jamaica. So that extradition treaty necessarily binds the process. So because of the way that they went about the extradition, perhaps they lost the charge. Whether that was deliberate or not, who can say? But now it says the prosecutor's like, okay, we can't charge you with a crime unto itself anymore, which is very sad for us. But we can use it to support the fraud charge that we already levied. So we'll use it as evidence of a charge rather than as a charge unto itself. So we're going to do that. He faces 5 other charges as well as his trial that's currently scheduled for March 2024, in addition to the one that's currently scheduled for October. Before his $250 million bail was revoked, Bankman-Fried was largely confined to his parents' home, which is a palatial mansion. It was a very nice, large estate. It's a nice place to be, you know. If you got to be under house arrest, I recommend it very much. You know, it's the kind of place everyone wants to be for house arrest. And he said, how about I don't do that? How about I get to go to the MDC instead? And I'm sure he's sad. He is pled, of course, not guilty to all his charges, but he's super duper guilty, and we all look forward to him being convicted. Thus, that brings us to the end of the case for the moment of Sam Bankman-Fried, who is currently scheduled for trial in October, and it looks like that might happen. Effed around and found out with respect to his bond being revoked because the court thought that he was trying to influence and interfere with witnesses. And it's like, yeah, we're not going to allow you to do that. And so now he's in prison. It's like, I want to meet with my attorneys every single day. There's so much things for me to go through. And judge is all like, nah, that's okay. You can meet with them for, these 6 hours or something, and hopefully that will help. And that's all you get as we're running up to the trial time. So yeah, so not so much. So yeah, and you get to just be treated like every other prisoner in the prison. So, and also they've already given him like extraordinary access and things like that anyway. So they've already given him like more than he's entitled to, but he wants more. He's so used to being given everything he wants. He doesn't understand being told no. And now the judge is kind of telling him no. I'm not sure whether or not he's gotten the hint yet, but we'll find out. And at least for the moment, that brings us to the end of discussion of this case. All right, good morning, everyone, and good morning to you, my friends on the Uncivil Law chats. I hope, as always, you are just having the most fantastic, wonderful day here on our Legal News Roundup. Thank you, Jules Buddha, as always, for the gift memberships. We do appreciate everyone who helps us support this channel by getting gift memberships or by buying them for others. So if you want to buy a gift membership for yourself, you can just hit that super chat button and click get a membership. It's only 99 cents. Or you can just follow the link that's given by the bot from time to time. That will help you get that thing. And then, of course, also you can hit the join button as well for all that stuff. We do appreciate everyone who helps to support the channel financially. It is extensively appreciated. Veronica celebrates 6 months of membership. Excellent. Glad to have you here, Veronica. I'm glad that you are here for 6 months of membership. Fantastic. All right. Now, on a personal note, I wanted to respond to a comment that was made in yesterday's live stream chat or live stream comments, because I thought it was an interesting comment, and I always appreciate anyone who tries to help me be introspective. Right? It's like people are, if people are, there's obviously a distinction between someone who's like trying to provide, what would you say? Someone who's coming from a good motive, right? So someone can come at you critically, and there's a difference if their motives are bad or their motives are good. And we obviously have our sources of trolls who are doing criticism not because they genuinely want you to be better, but generally just because they want to bring you down, right? Their motives in exposing your weakness is not to try to make you better, but rather to try to bring you down. And that's a problem. But, that's just because that's some people doesn't mean there's everybody. So I thought this comment was actually fairly insightful, and I thought we'd respond to it and discuss because I thought it provided a moment of introspection for me. So let's discuss this and weigh the merits of this comment, because I think there's some merits to it. All right. So this is a live stream yesterday, and let's give you the background of this before we read the comment. All right. So this will be, because otherwise it gets too meta, right? So I have to give you the background. All right. So the background of this is that on a live stream with Lawyer You Know, also known as Peter, he was reviewing a video in which a person, like on CNN, was commenting that someone else had gotten their way into a particular case. So I realize we're talking like three different levels. So Peter's reviewing a comment from CNN who is talking about someone else, right? So it's like, yeah. So anyways, so there's this CNN panel show in which this person is a talking head commenting about someone else who had tried to get their way into a case. All right. And the person on CNN talking about the other person said that they acted in a really ham-fisted, porcine way. That was the comment. The person on CNN said the other person, in trying to get involved in the case, had acted in a ham-fisted, porcine way. And of course, I took note of that, because I'm like, there's two pig references right back to back, right? It's not just ham-fisted, it's ham-fisted, porcine. And I'm like, okay, so he's trying to really make a point, and like whatever. So Lawyer You Know is watching the CNN person comment about this. So I make a super chat joke. And I'm going to paraphrase my own joke, but I said, did that CNN presenter just say that the other guy acted in a ham-fisted, porcine way? How very sus. The joke being that sus is the scientific name for pig. So, yeah. So that was the joke, right? So a lot of people didn't get the joke, which, okay. And then I gave another super chat to Peter in which I said, so I explained the joke. The joke was that sus is the scientific name for pig. Following the rule of threes, I wanted to give another pig reference because we already had two, right? So like there's that rule of threes in public speaking, or rule of threes in comedy. It's like you do three things, and you see it all the time in public speaking if you notice it. Like there's always three things in the list. So they gave ham-fisted porcine, right? So those are two things. So to fill out the rule of threes, I gave the third thing, sus. So I filled out the rule of threes with a pig joke, and also like making it like even like more elitist in some ways, because they said ham-fisted porcine. Porcine being a little bit more of an obscure word for pig, right? So ham-fisted porcine, rule of twos, right? I've taken ham-fisted and already escalated it to a more obscure word, porcine. So to fill out the pattern in the rule of threes, what would be, you need something even more obscure, right, to fill out the pattern. So ham-fisted, porcine, sus, right, because it's even more obscure to refer to the same thing. All right, so I'm filling out my rule of threes, finishing the joke, and then I said, so this is a deep cut pig joke. Does that make it bacon? I cannot be stopped. So I was very pleased at my own cleverness. I was very pleased at my own cleverness and delighting in my own cleverness at taking advantage of this opportunity. It's like, okay, this guy on CNN is already trying to make himself seem really like smart and really like whatever by saying ham-fisted porcine. He's taking this thing to make himself seem more important than he is. So I'm going to complete the pattern by going one step further in the escalation. So ham-fisted porcine sus, and finishing out the rule of threes to finish out the comedy. And then I made another joke about it. It's a deep cut pig joke, therefore it's bacon. So that was my sort of really sophisticated joke. Anyway, so that's all background to explain this comment. All right, so the person comments. This is Chelsea Whitaker. Chelsea Whitaker says the following. I love you and I love Peter, Lawyer You Know. I was there in the chat when you sent those super stickers. I thought the second one, deep cut bacon, was hilarious, and I said so in chat. All right, thank you. Just to be clear, I love your sense of humor. Mine is similar. The joke didn't go over my head, but to me, there was an attitude and even suggestion of, let's see how dumb you guys are, that was palpable. I actually tried to convince myself that there wasn't a bullying element to it, of putting people down or implying they're stupid, and too stupid to figure out the implication. And then a few minutes ago, towards the end of the stream, you retold the story of the joke, as I just did just now to explain this comment, so I had to redo it again, because otherwise I need the background so you understand what they're talking about. So then, as a few minutes ago, towards the end of the stream, you retold the joke, so basically just told you exactly what I just told you just now. You retold the story of the joke to support this idea that your sense of humor is too intelligent for LawTube. Your attitude of it went right over everyone's head, which you just said literally is exactly the vibe I got in Peter's chat the other day when this happened. You had an expectation before you even made the joke, and whether that expectation was or would be accurate or not doesn't matter. Your intent to make people who love you and your sense of humor look and feel stupid completely overshadows your would-be funny, if not shrouded in judgment, jokes. It's just a damn shame. It seems like I was the only one in chat that was present for all this on both channels, so I want to clarify out of respect for Peter and you. If you want to put people who support you down, that's your prerogative. But if that's not your intention, then I owe it to you to let you know what the experience was like as one of your supporters. Okay, I appreciate this comment. I accept this comment as intending to provide a constructive criticism, right? So, first of all, I value the comment. I value the comment, and regardless of whether I agree with it or not, in the end, I appreciate the respect of the comment. So I may wind up agreeing with this, I may wind up disagreeing with it, right? Because in the end, like, I have to be who I want to be. So even if I reject the advice, I appreciate the spirit in which it was given. So I want to make that plain, as sort of I'm trying to feel this thing out. Thank you, Alan Parker, by the way, for the 20 gift memberships. They're extensively appreciated. All right, so how do we feel about this thing? So I guess one way of phrasing this is, am I the asshole? I guess would be the sort of one way to view this. Am I the asshole? Because, like, I told a joke that I sort of understood at the time I was telling it was very sophisticated. Because I'm like, okay, I mean, I'm using what I know is, a reasonably obscure piece of knowledge, right? The scientific name for pig is sus. Like, not a lot of people are going to know the scientific name for pig is sus. So the joke only works if you understand the reference, which I'm like, people aren't going to get the reference because most people probably don't know the scientific name for pig off the top of their head, which I just happen to, and so I can make this joke in this escalating pattern, right? And so the reason for using the obscure term is to, as I explained, is like the rule of threes, and we're already in an escalation, right? So we have to continue escalating it, right? That's like one of the things you learn in improv, for example, is like continuing to like escalate things and move things forward and try to move things in an increasingly like trying to escalate things. So some of those ideas. So I told a joke with an idea that it was obscure, and it definitely was me reveling in my own cleverness. I don't know that I intended other people to feel stupid about it. I mean, I told a joke that, like, I didn't know how many people would get the joke or not get the joke. It seemed like most people didn't get the joke. It seemed like very few people got the joke. So I suppose one of the things you could value this from is in a sort of functional frame of comedy, right? So if the audience doesn't get the joke, then maybe you're not a very good comedian. So I don't know how to feel about this comment on a lot of levels. I don't really, just because I am amused by my own cleverness or amused by my own, knowledge base and making a joke that amuses me, I wasn't really intending to necessarily bring other people down. But that being said, my intent isn't necessarily the only thing that matters. Because if my audience perceives that I am trying to make them look stupid or make them feel stupid, or if I'm trying to insult them, if my audience feels like I am trying to bring them down or insult them, that's not good. I don't want my audience to feel like they're insulted. That's not what I'm trying to accomplish. I mean, I suppose there are comedians or acts which might endeavor to make the audience feel dumb or feel insulted. There are comedians or actors who might try to do that with deliberation. Maybe like a heel in a wrestling, right? Like a heel in a wrestler is trying to make you hate them, and so they're trying to get you into that state. So there's definitely like a role for that role, but that wasn't really my objective. So maybe this is just me smelling my own farts, and that's the problem, right? Maybe I'm just too like I'm too I'm too amused by my own cleverness, and maybe this is me just trying to desperately show off my own cleverness, and uh, that's not necessarily good. Uh, so I'm not 100% sure how to accept this comment. I mean, I definitely recognize the joke I told was relying on fairly obscure knowledge. I recognize that it was a clever joke. I recognize that it would go over people's heads. But I don't know that I was necessarily trying to induce people to feel like they're dumb or feel lesser or feel like I was bullying them. And so, but this person says that the vibe they got was one of me putting people down or implying they're stupid, which wasn't really my objective. So I'm not 100% sure how to interpret all that, to be honest, or 100% sure necessarily what to do about it. But maybe the right idea is I am too infatuated by my own cleverness and too infatuated by my own knowledge, and maybe at least at times I'm trying to overly prove like how well read I am or how knowledgeable I am, and trying to make my puff myself up with knowledge. So maybe there's something there that is cutting at some deeper aspect of me. So I thought it was a pretty interesting comment. So I don't know. I thought it was an interesting comment. I'm not 100% sure what to do about it. I don't want to make people feel stupid. Um, Also, you know, whether or not, you also don't want to necessarily go the other way and least common denominator this. You don't necessarily want to go the other way. And it's like, you know, if you want to tell a sophisticate joke, right, then to make it non-sophisticate kind of defeats the point. So, you know, but then again, maybe the sophistication is the problem. So I don't know. Yeah. So that was some interesting stuff, and I thought we would talk about that a little bit. So let's respond to some of your comments as I've been talking for a while, trying to muse this out because I thought it was an interesting comment. I thought we'd give it the yeah, thought we'd give it some weight. Robert Toast says nerd humor is the best because people don't get it. Maybe there's something to that. Fair enough. Sometimes part of the joke is that it does go over people's heads. Maybe. I think that's most commonly true. For example, where like you slip in an adult joke into a children's cartoon, and so the joke goes over the children's head, but the adults catch it. Rubber Toe says, yes, you're the asshole, but funny asshole. And that's what comedy is sometimes. It wasn't a personal attack. No, it definitely wasn't a personal attack. That's true. Um, I think asshole can be a form of comedy. I don't know if it's necessarily required, but maybe. Too High Strong says she makes a good point. Often you misread the audience and comes off as condescending sometimes. That's fair. Although partly that's at least partly a limitation on the medium of our exchange because unfortunately I only have the text of your words and I don't have your body language and I don't have your vocal tonation and like so a lot of the meaning is is lost in communication. So and also uh, sometimes I misperceive the intent behind something because unfortunately we have trolls. And so sometimes someone who is not a troll will say something and I perceive it as a troll or I perceive it as an attack because unfortunately I have attacks that come my way. And so I am perhaps, it's sort of my filter, my filter friend or foe filter has been antagonized. And so sometimes I misread a comment because, I have become overly sensitive because I've been, subject to attack. But yeah, so yeah, I don't mean to come off as condescending, but I definitely could see how I could be perceived as condescending, and definitely need to try to work on that a little bit. Isabella Mars says the point wasn't to be funny; it was to boost your ego. Hmm. Well, maybe both, but fair. Cast the sass. I think knowing your audience is a big part of comedy, and I do think sometimes it can come off as condescending. Fair. That's a reasonable point. Yeah, knowing your audience. And so, yeah, telling the joke to the right audience at the right time. Hmm. Which one wonders if that joke, what that audience would be good for. Maybe it would be good for like a pig convention, like a farmers convention of pigs or something, because maybe that joke would play well among farmers. Maybe it's the wrong audience. Aaron says, I understand how you can see this as constructive criticism and respect their opinion as well. However, I think this person is projecting their own feelings. They really can't speak for anyone. Well, yeah, well, they're describing their own feelings, which are valid. I mean, as far as they go, right? Whether I should change anything because of their feelings is a whole nother set of problems, right? Just because you feel a particular way doesn't necessarily mean that I should change my behavior. Because if it did, then you, through manipulation of your feelings, could manipulate my behavior, and I have no autonomy left, right? So, if your emotions necessarily required me to change my behavior, then all you have to do is change your emotions to change my behavior, at which point you can engage in emotional manipulation, right? So it can't be the case that your emotions necessarily dictate my actions, but I should be aware of them and be like, okay, I'm going to do this regardless of how you feel about it. It's like your feelings are interesting and all, but I don't care. I want to do it anyway. Or I do care, right? I do care about your feelings. And so I'm trying to tease this out a little bit and sort of trying to feel this out about how I feel about the whole thing. On my end, it's like, okay, here's a person with constructive criticism. They feel a certain way. I'm going to consider their viewpoint as I try to analyze whether or not I want to change anything because of it. So the end of this could be, right? The end of this could be, no, I disagree. Or the end of this could be, yes, I agree. Or it could be somewhere in the middle, I suppose, too. Right? I agree in part, disagree in part, whatever. But it's like I have to consider the proposition. So their feelings are as valid as far as they go. What that means for me is a whole nother set of problems. But yeah. Rosie one says comedy is hard. That much is true. I read her comment yesterday and today realized how excited you were to put what you're learning improv. I don't think you were bullying, just excited to pull off such a great threes. Yeah. Diamonds diamonds and henna says, I mean, that's kind of your thing. You like to flex your knowledge. Yeah, maybe that's not necessarily a good thing though. Maybe me flexing my knowledge is me being just an erudite, pompous jackass, which I don't know. That's necessarily good. I don't know if I want to be an erudite, pompous jackass. Catherine says, I think it would have worked if you used the bacon line first and then you sus as a finale. You're too amused by your own cleverness. That's okay, but understand when people are not amused. Yeah. Which makes me want to, well, I also want to be liked. I also want to be liked and, you know, attract women and other things too. So my own cleverness isn't necessarily the only thing that matters. So as I try to reevaluate how I conduct myself and how I hold myself out, as I try to meet my many objectives, for example, increasing this channel, increasing my subscriber count, increasing watch time, being more likable, being more well received, having more women in my life, and so forth and so on, I have to consider a whole bunch of propositions. And so if I am too amused by my own cleverness, maybe I need to either tone that down or I need to otherwise rebalance things so that I can achieve a more wide swath of my objectives. But thank you very much for your comment. Hill CT says, it took me a moment to realize what you're saying at the time. Then, having recognized the attempt at humor, I was slightly annoyed that wasn't sufficiently to justify the time spent. So maybe it wasn't a very good joke in the end. Yeah, fair enough. Hans Van Gretchen says, Suddenly looks at watch. Unfortunately, that's all the time we have for today's session. Okay, well, I mean, if you don't want to discuss this anymore, we can move on to our things, I suppose. I just thought it was a valuable exercise. But if you're telling me that you don't want to discuss this anymore and this is not a valuable exercise for you, then I don't want to deprive you of the reason that you're here. So we can move on to our things. I appreciate your indulgence. All right. In freedom of speech news, a federal judge has dismissed a second lawsuit over a Black Lives Matter poster that was posted in a school. Some people objected to the poster in the school, but of course, Black Lives Matter is a viewpoint and people can express viewpoints. So the problem might not be the Black Lives Matter poster itself, the problem might be other viewpoints that aren't being represented. But let's learn a little bit more about these posters and some of the First Amendment issues that are in play. Let's get started with this. A federal judge has dismissed a lawsuit of a group of parents and taxpayers brought against a school district in hope of getting Black Lives Matter posters banned from the community schools. The U.S. District Judge dismissed the lawsuit, stating the posters constituted governmental speech and therefore did not fall under a First Amendment challenge. So, as we've sort of discussed before, the government is also entitled to speech if it likes. So, if it wants to post certain posters or certain ideas, it can do so. And what other people are allowed to do for their speech also gets into issues. So if the people want to wear other kinds of shirts or spread other kinds of messages on their own right, and the school is trying to prevent them from doing that, we would have a different issue. So if someone wore a shirt saying Black Lives Don't Matter or something, and the school tried to oppress them, then we'd be talking about that oppression. But the issue is here whether the government is allowed to speak on its own right, the answer to which is yes, as a matter of law. So the fact that they post their speech is not necessarily a problem. According to court documents, after George Floyd was murdered by the Minneapolis police in 2020, school administrators, staff, and teachers joined much of the country in finding ways to support their students, including Black Lives Matter. The school board participated in this exercise when they vetted and authorized a multicultural poster series, including 2 posters that read Black Lives Matter. So the school wants to spread a certain message. The school district wants to spread a certain message. You may not agree with that message. That's okay. You have freedom of speech too. So again, if the issue is they were trying to prevent you from speaking, if the issue is they're trying to prevent students from speaking, if the issue is that only certain viewpoints were allowed to be spoken, then you'd have a problem. But as long as the government is allowed to speak on its own right, you don't have a problem. So this doesn't form a problem in and of itself. The court noted that not everyone supports the decision, believing the posters carry political messages, which maybe they do. Some parents and students objected to hanging Black Lives Matter posters without also displaying posters offering other viewpoints. But the school district itself is not required to forward other people's message. The school district itself can choose a preferred message. So as to their own speech, they can discriminate in the same way that you can discriminate as to your speech. You don't have to express messages that they don't like, and vice versa. They don't have to express messages that you don't like, or whatever, right? So the issue is, should the school be forced to express these viewpoints? The answer to which is no. The Lakeview School Board denied their request, and first of 2 federal lawsuits were filed. The plaintiffs included a woman whose daughter, who's then 9, went viral when she rebuked the school board for displaying the posters in her school after saying such political messages aren't allowed. Others joining in and suing the school district included residents and others who joined in anonymously. Some of the plaintiffs first sued in August of 2021. However, that lawsuit was dismissed because a judge found the plaintiffs lacked standing because the daughter no longer attended schools and because the residents didn't pay taxes directly to the school district, but rather indirectly through the county and state. So there might be an issue of standing here, although one might note that this is an issue capable of repetition. So because the person graduated doesn't necessarily preclude standing, but this judge thought that it did. So I'm not sure if I agree with that part of the decision as to standing, right? The injury did occur at a place and a time. The fact that they graduated doesn't prevent that past injury from being redressable. So I think I disagree with the judge as to that part, but that's what that judge said. A second lawsuit was filed in September 2022, listing the person's other children who still attends the school as plaintiffs. According to the complaint, the then superintendent in September 2020 told teachers not to display Black Lives Matter posters in their classrooms and informed families that such posters violated district policy against political endorsement. So the superintendent at one point said, okay, this is a political message or a political endorsement. It endorses a particular political view, which we're not supposed to do. So that's one issue. Is this a political view or not? Which I suppose is a little bit in the eye of the beholder. The following spring, however, the district ordered a series of inclusive posters, 2 of which said Black Lives Matter, and distributed them to staff members upon request. In April 2021 report to the school board, Administrators said the posters were intended to support staff in creating school communities where students are respected, valued, and welcome. When someone asked that all lives matter or blue lives matter posters also be displayed, the equity director responded those slogans were created specifically in opposition to Black Lives Matter, which, even if that's true, doesn't necessarily solve the problem. So even if it's true that those slogans were created in opposition to Black Lives Matter, that may itself be the point. And discount the struggle faced by black students and others in society, the complaint said. Well, maybe, maybe not. I mean, I thought you guys said that saying Black Lives Matter doesn't mean that all lives don't matter, so I'm not sure it necessarily discounts the struggle, but you figure it out amongst yourselves. The plaintiffs claims the district refused to give equal space to this message violates the First Amendment prohibition against viewpoint discrimination. They also said the district's poster create a hostile education environment for the white children, which, okay. In the order of dismissal, the judge said the central issue was whether displaying Black Lives Matter posters violated the constitutional rights by endorsing what they claimed was a hostile political ideology. Because the display of the posters constitutes governmental speech that is not subject to the First Amendment challenge, because again, it's the governmental speech, so it's the government speaking, so you can't complain about their First Amendment speech any more than they can complain about your First Amendment speech. That's the way this goes. The school board motion is granted and the lawsuit is dismissed, the judge writes. Thus, that brings us to the end of the article for the moment about the federal judge dismissing a challenge over a school board that decided to post Black Lives Matter posters. The federal judge ruling, apparently quite correctly, that the posters constituted the speech of the school, in which case they are under no obligation to represent all their viewpoints. Now, if other people want to make posters of their own, if other people want to put on shirts of their own, if other people want to spread messages of their own, and the school district doesn't allow other people to speak, that might be the problem. So it might not be the problem that they are not allowing the posters on their own walls, but if they don't allow other people to, spread messages that are contra in their own way, then that would be viewpoint discrimination, because at that point, the government is saying only our viewpoint is allowed, which isn't quite the same thing. So the government is allowed its choice of posters. That is not the problem. If you can show that the school district is preventing other people from spreading their own messages contra, then you might have a viewpoint discrimination claim, but not the way that this was phrased. So at least for the moment, that brings us to the end of discussion of this case. Push the button. Great. Let's see what else we got. Okay. In Andy No news, Andy No has been awarded $300,000 after defendants that he sued disregarded lawsuits regarding a Portland protest assault. So Andy No, as I'm sure many of you are aware, is a somewhat controversial reporter who goes around and he reports on things and sometimes is assaulted and beaten up, and he'd like to sue. And so he has sued at least one group of people who then decided not to show up to the lawsuit. So he wins his default judgment. So let's learn a little bit more about what happened in this case. Let's get started with this. All right. In a recent ruling, three individuals who failed to present a defense in court against a lawsuit accusing them of assaulting the conservative writer Andy Ngo during a 2019 protest in Portland have been ordered to collectively pay Ngo a sum of $300,000 for the assault. The defendants in the case, who Ngo claims are members of Antifa, are Catherine Belai, Madison Allen, and Joseph Evans, or at least he was Joseph Evans at the time the lawsuit started. He has since changed his name. His name is now Sandwich Overkill Shot Deputy. Sandwich Overkill Shot Deputy. That's his name now. Okay. Despite a last-minute effort by an attorney representing Joseph Evans, who now legally goes by the name of Sandwich Overkill Shot Deputy, to contest the default judgment, the judge declined the appeal, citing the lawsuit's 3-year history. So yeah, it's like you have chosen not to participate in this thing for 3 years, and after a while, the judge is going to give up, right? They're going to avoid a default judgment. It's not one of their favorite things to do, and courts will tend to go out of their way. They'll tend to bend the rules a little bit, even, to prevent default judgments. So it's a little bit unusual. In fact, it's extremely unusual to get a default judgment for, minor technical violations, or even like the first couple times you're in abeyance of the rules. But after a while, the judge is going to give up. And so the judge gave up, and the guy's like, wait, no, I'm ready to participate now. And he's like, well, Mr. Sandwich, if that is your name, which apparently it is. Okay, Mr. Sandwich, no, you haven't participated this long, so you don't get to participate now. We gave you every opportunity. That's over now. So how about you just pay? Born in 1986, Andy Ngo is 37 years old. He's an American journalist aligned with right-wing perspectives, recognized for his roles as an author, social media influencer, and coverage involving documentation of various demonstrations. He holds a position of editor-at-large at the Post-Millennial, a conservative news platform in Canada. His writing contributions have encompassed columns featured in the New York Post and Wall Street Journal, among other independent reporting, so he definitely gets around. The three individuals who are involved in this are Catherine Belai, Madison Allen, and Joseph Evans, also now known as Sandwich, Shot Deputy. The judge asked damages to be equally split among the three non-participating damages, so they are severally liable. The court found that Shot Deputy was among the initial aggressors who struck Ngo during the Portland protest. Madison Allen was implicated by hitting Ngo on the head with a sign, while Catherine Belai was accused of tossing a milkshake at him. Your milkshake may bring all the boys to the yard, but you can't throw it at them during a protest. You can't do that. Also, by milkshake, what exactly do we mean? Because some of these milkshakes were actually like concrete and stuff. So unclear what we mean exactly by milkshake, because yeah, some of the things that were thrown were not exactly what you consider to be a typical milkshake. The actual trial lasted all of about an hour because, as I mentioned, they didn't show up to participate in the case. So it was pretty easy because, they didn't show up. Ngo filed a lawsuit in 2020, and this is therefore turned into a 3-year-long legal case, which is probably part of the reason the judge finally gave up hope. Via a remote video statement, Ngo conveyed that those who wish to harm me, they always refer to it as milkshake incident to mock my injuries and celebrate it. The near-death experience, to be continually be a joke to be violent extremists, is distressing and scary. Yeah, he definitely has been a victim of much violence, to be sure. During an earlier trial, activists John Hacker and Elizabeth Reichter were found not guilty of causing harm to No for being unmasked in assault, which, fine. I mean, whether or not they're criminally guilty and whether or not they're civilly liable, as always, two different issues. So are they criminally responsible? I don't know, but there seems to be some civil responsibility. In striking contrast to the weeks-long trial held earlier in June, the brief hearing in August presented a markedly different scene. The subsequent hearing, presided over by the judge, the certainty of the verdict was unquestionable because, as I mentioned, they didn't show up. So if you don't show up, you're going to lose. That's what default judgment is for. Thus, that brings us to the case of three people pictured here: Madison Allen, Catherine Belay, and Sandwich Overkill Shot Deputy, all of whom look like upstanding members of society. Who would have ever thought that any of these people could be involved in anything, especially Shot Deputy over here on the right with the blue eyeshadow and blue lip and the piercing through the nose and the bridge of the nose, and so these people owe Andy No some money, so better have my money when I come to collect, I guess, as Andy No gets ready to try to figure out how to get this money from these three people who I assume have no money, but we'll try. And at least for the moment, that brings us to the end of discussion of this story. Button. Thank you. Reminder for the button. Thank you for the reminder, Tony, for saying change the button. We do like to change the button. All right. New story. New story. Tina says, there goes the makeup money. Well, you see, if you do makeup the way I do, it's not very expensive. But then again, maybe they do makeup differently. So the kabuki brush continues to kabuki. I'm not sure if it is better or worse than the powder brush, but well, we're doing it. So yeah. All right, let's do another one. In electrical vehicle, let me try that again. In electrical vehicle news, the state of Texas is now billing electrical vehicle owners an extra $200 as part of their registration when they get registration every year. This amount is to help get the money that they would get from the taxes that they charge on gas. But of course, electrical vehicles don't use gas. So therefore, they're not getting the tax, but they are using the roads. So a lot of governments, including Texas, use tax money on the gasoline to get money to pay for roads. But of course, electric vehicles don't pay that tax. So they're like, okay, how are we going to solve that problem? Well, the state of Texas has solved that problem by, how about you just give us $200 every year and we'll call it even. So basically you just pay a liquidated tax. Instead of doing the tax with the gas, you do the tax up front, regardless of how much you drive, incidentally, because we had to pick a number, and the number we picked was $200. So that's what Texas went with. So let's learn a little bit more about this. While waiting for a battery in his Tesla to charge, a traveler cleans his windshield at a service station in Chaldas. Starting September the 1st, the electrical vehicle owner in Texas will have to pay a state fee aimed at making up for lost gasoline taxes. So he is cleaning his windshield at the service station, but not paying for gas and not paying the gas tax. So Texas would like its money, so they'll find some other way to get it. Plano resident Tony Federico bought his Tesla 5 years ago in part because he hated spending money on gas. But the financial calculus will change September 1st, when Texas will start charging electric vehicle owners $200 every single year. So yeah, regardless of how much you drive, we want $200. It's like there's a lot of ways we could go about this, right? Some states have been thinking about a per mile fee, like with GPS or something, GPS tracking. And Texas over here is like, that seems a little invasive. So we're just going to charge a flat fee, $200. Some people probably don't drive that much. Some people drive a lot more. But $200 we think is the right number that sort of averages out to work out for everybody. So you pay your gas fee, as it were, up front. It seems like it's arbitrary with no real logic behind it, said Federico, but I'm going to have to pay it. Yeah, I'm not sure it's necessarily arbitrary within the meaning of the law, right? When we talk about arbitrary, we mean without rhyme or reason, without any sort of methodology or without any sort of calculus. So $200 per vehicle per year is, I'm sure, the amount. I'm just gonna go with the assumption that it's the amount that they thought that would be on average the amount that would pay for gas taxes. Some people more, some people less, but it all averages out to be the same. We had to pick a number. $200 seemed like the right number. It's like the same thing as like a drinking age or any other number that you pick, right? You have to pick a number. It's like if you're going to pick a flat number. Is the flat number arbitrary? Not within a legal sense. No. We had to pick a number. This number was the number we went with. It could have been less. It could have been more. We picked this number because that was the result of our negotiations. So not arbitrary within the meaning of law, no. Earlier this year, the state legislature passed the Senate bill, which required the electrical vehicle owners to pay the fee when they register their vehicle or renew registration. It's being imposed because the lawmakers said that the drivers weren't paying their fair share into the fund that helps cover road construction and repairs across Texas. So, there are a lot of vehicle owners out there not paying, so we'll figure out how to get that tax money. Nothing's certain but death and taxes, as they say. And Texas is like, how about $200 every year? So that will do fine. This cost will be a bit higher for those who purchase a new vehicle, because when you purchase a new vehicle in Texas, you pay for 2 years of registration instead of just 1 year, so you have to pay for $400. So when you buy it brand new, it's a 2-year registration. And then when you renew it, it's registered for every year. So you have to pay $400 up front because, you're getting 2 years of registration. The Texas agencies estimated in a 2020 report that the state lost an average of $200 per year in federal and state gasoline taxes when electrical vehicles were replaced by a gas one. So they did a report and they said, okay, we think that we're losing about $200 on average. So how about if we just charge a tax of $200? So see, it's not arbitrary. They did a report. They did a study and everything. They said, we think it's about $200 a year. Therefore, let's charge $200 a year. Some people will be more, some people will be less, but it will average out to the right number. So, fine. Gasoline taxes go to the State Highway Fund, which Texas Department of Transportation calls the primary funding source for road work, because of course it is. Electrical vehicle owners don't pay taxes because they don't use the gasoline on which the tax is charged. But they do, of course, use the roads. And while electrical vehicles may be only a tiny portion of cars now, that fraction is expected to increase. So we'd like to make sure that we get that money for all the vehicles registered in Texas. Texas is a big state, home of Tesla, home of a lot of other places. And so, we want to make sure that we get our tax money no matter what you do. So gas vehicle, we'll charge you based on your actual usage, based on how much gas you use. For the electrical vehicles, we could do some sort of GPS monitoring, or we could do some sort of calculation based on, the average, the odometer or something. But we don't want to do that because we think, it might be too burdensome or interferes with people's privacy. So we'll just do $200 and that will be fine. Many environmental and consumer advocates agreed with lawmakers that they should pay into the highway fund, but of course there was a dispute over how much. Some thought that the state should set the fee lower to cover only the lost state tax dollars, rather than both state and federal, because federal officials may devise their own scheme. Yeah, maybe they will someday. Maybe they will someday, but they aren't for now. So for the moment, those monies are being lost, and Texas would like those monies back. And if the federal government does devise its own scheme, maybe you can ask Texas to lower the amount. Whether they will or not in that event, who knows? But yeah, so for the moment, there is no federal plan in place, so we need to cover that. Others argued that they should charge nothing because EVs help reduce greenhouse gas emissions that drive climate change, which, maybe, but they still are a burden on the roads. We urgently need to get more electrical vehicles on the road, said the executive director of Environment Texas. Any increase of a fee could create an additional barrier for Texans, and particularly more moderate to low income Texans, to make that transition. Which, if you're buying an electrical vehicle, they tend to be a little bit more expensive. So I'm not sure how many moderate and low income people there are buying pure electric vehicles, but whatever. And of course, it's $200 regardless of the cost of the car, because it was based on the gasoline tax, which is also regardless of the cost of the car. So it doesn't matter whether you're driving a Honda Civic or a Ferrari. Gas tax is exactly the same. It's the exact same thing. Now, how much gas you use will be a bit dependent on the nature of the car, MPGs, and all the rest of it. But the same gas goes in the car, was my point. And so, right, it's like, yeah, so this cost is also irrespective of the cost of the car, but that's sort of in the nature of the thing, so fine. Tony Smith, the executive director of Texas Electric Transportation, advocated for a fee based on how many miles a person drove, which would better mirror how gas taxes are assessed, which makes sense. But then, of course, you have to actually track that in some way. So you have to figure out what that is. So either you do some sort of GPS monitoring, or you get that number reported when they get the inspections done. But there's some compliance issues with that. People might try to cheat the system. People might try to falsely report their numbers. There might be fraud issues and all the rest of it. So Texas is like, okay, we could do it with reporting by mileage in some way, but that's just, too cumbersome. How about just $200 across the board? So some people less, some people more. That's what we decided on, and that was Texas's approach. So a reasoned approach. You could obviously do it a different way. It's not the only approach. But then again, when you're looking at the governmental action, you're looking for a rational basis. So just because there are other ways to do it, even ways that are arguably better, doesn't matter. Is this a reasonable way to do it? And the answer to that question is yes. It is a reasonable way to do it. So Texas can make that choice. Other states can make other choices, and we all move on with our life. Thus, that brings us to the end of the article about Texas putting in place a new tax with respect to electric vehicles, designed, at least in part, to help recoup the money that they would have gotten from the gas tax the EVs are no longer getting. So because you're not using gas, you're not paying your gas tax. You were paying both federal and state gas tax, and we were getting some of that money back from the feds. So we're losing out on that money. So we'd like to recoup it. How much is the loss? About $200 a year, says the study from the agency. It's like, okay, fine. We'll set it at $200. Some people will pay more. Some people pay less. Some people don't drive that much. Some people drive more, but it all works out in the end. And it's a nice, easy administration, right? So it's $200 per electric vehicle, regardless of mileage. We don't have to track the mileage. We don't have to get our inspection stations to report it. We don't have to ask people to report it. We don't have to do some sort of sophisticated GPS thing. How about just $200 per person, and we'll call it a day? So, that's what Texas is doing. So that is what's going into effect as of September 1st, at least for the moment. That brings us end of discussion of this story. Push the button. Great. What's next? Mm-hmm. All right. All right. In not as much defamation as you thought news, a $1.4 million verdict has been reduced to $71,000. Well, that's a lot of change. That's a lot of change. That's 1/20th, right? So how about 1.4 million, you say. How about 71,000? 71,000 is almost as good as 1.4 million, right? 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 You know, is five, how about 5%? So the court said, how about 5%? All right. So let's learn a little bit more about this reduction of award in the hashtag they lied Renaissance Fair liable case. Renaissance fairs are always fun. Let's learn a little bit more about this defamation and the reduction of the award. Let's get started with this. From the decision of Amore versus Conover in the Eastern District of Pennsylvania by Judge Gallagher. In this case, the court must decide whether defamation damages sustained by the plaintiffs, who are the king and queen of a Renaissance fair, cut to the bone or merely just a flesh wound. The judge starting right away with their metaphors, which I am all here for. So the king and queen of the Renaissance fair have been harmed. Can they recover? Here the plaintiffs accuse the defendant of defamation for publishing accusations about the plaintiffs in their capacity as Renaissance Fair performance directors. So apparently we have some issues with the Renaissance Fair. Renaissance Fair is real. I used to love going to Renaissance fairs. I haven't been to a Renaissance Fair in a hot minute. I would love to go to a Renaissance Fair again. I'll even dress up in costume if you like. And we are taking our Renaissance Fair very, very seriously. And we are saying that these people are not very good at their job at the Renaissance Fair. After the jury found for the plaintiffs, defendant now seeks to vacate the judgment and the $1.4 million award assessed by the jury. Because a reasonable jury, making its own determination as to credibility of the witnesses and applying applicable legal standards, could have found for the plaintiffs in this action, the motion will be denied insofar as it vacates. So the judge is like, no, a reasonable jury could have found for the king and queen of the Renaissance Fair. So, you know, you have insulted them, sir. You have insulted them, sir. You have bitten your thumb at them, sir, and you are responsible. However, because the jury's award of damages was unreasonably excessive in light of evidence presented at trial, the total amount of damages, how about $71,500? So yeah, instead of the 1.4 million, how about 5%? How about 71,000? Good times. For reasons that follow, the court remits the compensatory damages from $750,000 to $50,000. So how much have you been harmed, right? Compensation damages is all about how much harm have you had? How much actual loss have you had? What dollar amount would actually compensate you for your loss? How much bad stuff happened? The jury said 750. The judge says, how about 50? So we think that they went a little bit overboard. They went a little bit overboard by about 15 to 1. So how about 1/15? How about 50,000 instead of $750,000? How about instead of punitives, how about from 250,000, how about to 1,000? How much to punish these people? How about $1,000? 250,000 is too much. The compensatory damages to the other person, how about not 300,000, how about 20,000? And punitive damages, 100,000 to $500. So yeah, not all is necessarily going great over here. We've had some harm, the judge says, but not as much as the jury said. The jury went a little bit off the rails. And so we think that, we're going to reduce this down. Let's learn a little bit more about what happened. The plaintiffs initiated this defamation action by a complaint in December 2021, alleging the defendant deliberately, recklessly, and maliciously published defamatory statements against the plaintiffs, who both worked as assistant directors at the Pennsylvania Renaissance Fair and performance directors at West Virginia and Pittsburgh Renaissance Fairs. As the performance director, Dr. Amore testified his responsibilities are to supervise the Renaissance Fair cast and actors, as well as coordinate with independent or national acts that participate in the fair as well. In addition to the Renaissance Fair involvement, the plaintiff, Dr. Amore, is a dentist with a business practice located in Pennsylvania. So, dentist by day, Renaissance king by night. Well, it is an interesting life, to be sure. The defendant, who is one Miss Conover, was a paying guest at the Pittsburgh Renaissance Fair, and they also maintained an online blog where she wrote, among other topics, the plaintiffs, the king and queen. So she's a guest. She likes to go to the Renaissance Fair. She runs a blog. She'd like to talk about the Renaissance Fair. Okay. The blog statements in question claim the plaintiffs refused to take seriously allegations the Renaissance Festival cast members, under their supervision, committed sexual misconduct against other festival cast members, some of whom were minors under the age of 18. So this woman, who is a guest, says that the Renaissance Fair is not taking seriously allegations that some employees are committing sexual misconduct against other employees. Okay, so I'm not sure on what basis she thinks that she knows that, because she's not an employee. She's just a guest. And she just wants to write a blog saying that the king and queen over here are not taking the seriousness nature of the sexual misconduct allegations. Okay. According to the complaint, the statements further allege that they retaliated against the sexual assault victims by, among other things, publicly humiliating them, calling them crazy, refusing to rehire them, and or terminating them from employment. Yeah, I have a question. I have a question. How do you know any of these things? How do you know any of these things? You're not an employee. You haven't witnessed this, presumably, personally, right? So how do you know this? On what basis are you saying these things? On what basis are you saying these things is a good question, right? What is your basis for believing these to be true? The court concluded the plaintiffs were limited purpose public figures, which, as a matter of law, probably, but I have questions with the law, but that's for another time. So the jury, to find for the plaintiffs, had to find that they knew the allegations were false or reckless disregard. The jury did find for the plaintiffs in awarding the doctor some money and awarding the other woman some money. The plaintiffs alleged that the defendant, through their blog and social media posts, published false and defamatory statements concerning the plaintiffs. Among the evidence introduced by plaintiffs were statements published by the defendant referring to plaintiff Dr. Amore as the devil and a human monster, accusing plaintiff Dr. Amore of attacking a victim of sexual misconduct and gaslighting her, claiming the plaintiff Dr. Amore told the same victim that she was a liar and would not even begin to entertain the crazy accusations, stating that Dr. Amore had been aiding and abetting a P word for 2 decades. Well, that's pretty serious language. That's pretty serious language. I mean, publicly accusing you of aiding and abetting a P word and doing so for the last 2 decades. That's a pretty serious accusation. On what basis are you saying these things, ma'am? Comes directly to mind. And that Dr. Amore engaged in consistent verbal abuse and threats towards the Renaissance Fair under his supervision and made fat jokes, stupid jokes, race jokes, and autism jokes in the presence of cast members, okay. Defendant published statements also claiming the plaintiff verbally and physically abused his wife, who was also a plaintiff. Yeah, that sounds like a lot. That sounds like a lot, ma'am. You are accusing these people of engaging in some fairly reprehensible and also illegal behavior, engaging in a conspiracy cover-up of the sexual assault and defending and supporting a P word for the last 20 years. And also he hits his wife. That's a lot of things. So yeah. Plaintiff also introduced evidence the defendant published the statements online accusing the plaintiff, Miss Amore, of requiring a victim of assault to work with her alleged abuser at the Renaissance Fair, and claiming that Miss Amore told a victim she was being immature and dramatic for refusing to work with her abuser, and claimed that she should get over it. Wow. When the victim told Miss Amore that she had been sexually assaulted, the defendant wrote that Miss Amore laughed and told the victim she was crazy and should go home. That's a lot of statements of fact. That is a lot of statements of fact. And so the jury apparently found that these were false and knowingly false or recklessly disregarded. So, yeah. Here, because a rational jury could find from the evidence introduced at trial that plaintiffs satisfied the defamation burden of proof, they must let the verdict stand. So the judge is all like, yeah, well, these are limited purpose public figures, which, I'm not sure they are, but let's press past that issue for the moment and just accept the reality that the judge said they're limited purpose. So the jury, they have to prove that the woman lied knowingly or recklessly disregarded the truth. And apparently there's sufficient evidence that the judge is like, yep, they could do that. They could reach that conclusion. They could reach the conclusion that the woman knowingly lied or recklessly disregard the truth of her statements. In other words, she's a Karen without a cause. So, not great. So the verdict has to stand. Defendant argues the evidence showed that she did not knowingly lie during the publication of her statements in question, or have serious doubts as to about the truth of the publication. And to a reasonable observer, that might be the case. But the question here in deciding whether to take the extremely rare remedy of the jury verdict is not whether the evidence could support a contrary finding, but whether there's a minimum quantum of evidence. So the judge says, okay, look, your argument is that the evidence supports the conclusion that I did not knowingly lie and I did not knowingly disregard. The court is not even disagreeing with that. The court is not even disagreeing with it. The court is saying, yes, maybe a reasonable jury could conclude that you did not knowingly lie. Maybe a reasonable jury could conclude that you did not recklessly disregard. That might be a thing a jury could do, right? A reasonable jury might have been able to go the other way. The question isn't whether a reasonable jury could have found for you. That isn't the issue anymore. The issue is, could the jury found the way they did? Not is a verdict for you reasonable, but is a verdict for the other side reasonable? And they can both be reasonable because the jury is the finder of fact. The jury, it's up to the jury to choose to believe which witnesses to believe. They can believe witnesses in whole or part. They can disregard evidence in whole or part. So basically, it's up to the jury to determine what evidence they consider and how and what way to consider it. So could they have found for you? Sure, they could have, but they didn't. And so that also is reasonable. So, tell it to the jury, as we say, and you did, and they didn't find for you. So sad. So sad. It's a sad, sad situation. As to the damages, although plaintiffs as limited purpose public figures who prevailed on the claim of actual malice are entitled to damages, they're not entitled to excess damages, unsupported by the evidentiary record. So yes, while you're entitled to win, you're not entitled to win more than the evidence demonstrates, which, fair enough. So what is the maximum amount a jury could find for, and did they go past the rails? At trial, plaintiffs offered very different and vague evidence of damages. The plaintiff testified that defendant published statements could hypothetically harm his reputation and business because I'm dealing in a position as a dentist where I have a certain amount of public trust in my ethics, my morals and abilities, basically. And if those things are brought into question, I could lose the confidence of my patients in what I do. And also, we're dealing with actual allegations of criminal activity. That's a violation of the moral code and the dentist code. And basically, the State Board of Dentistry could pull my license. The accusations of assault of a minor, by law, I'm required reporter of a child abuse in the state. If I know the victim, I must report suspected child abuse to the state. So it's like, yeah, this goes to my professional reputation. It goes to harm. You say I'm a child abuser, which would make me also a mandatory reporter of the abuse that I myself committed. So, you're accusing me of all kinds of professional misconduct. So, yeah, but a lot of this seems a little hypothetical. So that seems to be part of the problem. The doctor testified that he suffered emotional injury as a result of the defendant's defamatory statements. The doctor stated he now has a much tighter and smaller group of friends and does not sleep well at night. The doctor testified he sought and obtained medication to treat his sleeping difficulty. The plaintiffs proffered no clear evidence of the doctor's private dental practice suffered any loss due to defendant's defamatory statement. So if you had loss of business, then fine, but that didn't seem to actually happen. Dr. Amore also testified he sought damages from the amount of time he spent reviewing defendant's defamatory statements and searching for an attorney. Based on the available evidentiary record, therefore, the court finds damages award of $750,000 in compensatory damages, $250,000 in punitive damages, and $300,000 in compensatory damages and $100,000 in punitive between the two people to be excessive and unsupported. There's no evidence to support the claim the Amore sustained economic damages commensurate with the award amount. The doctor himself said it would be very hard to tell whether he lost any patients as a result of the statements. So he doesn't seem to know that, so that's a problem. The plaintiffs didn't offer any evidence as to job loss, suspension, pay decrease as a result of the statements. Plaintiffs did not offer any evidence demonstrating even approximately how many people saw and read defendant statements. Looking to related cases, it's clear the doctor's sleeping difficulties, decision to maintain a tighter circle of friends, and time reviewing and assessing defendant statements in support award of some damages, but not the amount that was there. Further, it's unclear what evidence, if any, plaintiff presented as to Miss Amore's economic, emotional, or reputational images. So, as to the doctor, it was thin, and as to his wife, even thinner. The court's determination is supported by review of relevant, similar case law. Defendants' defamatory statements were substantially less in volume and were not published or broadcast to a national audience. This is in compare to other cases, right? So one of the ways that you determine how to set damages is by comparables, right? How much is the proper award? One of the ways to determine that is by comparables. It's the same way you determine how much a house is worth, at least in part, right? How much is a house worth? Well, how much are other houses that are around worth that are comparable, right? So, and looking at the case law, the damages where the amount was higher included, for example, broadcast to national audience, and that's not present here. So that therefore there's less damage because the scope of the defamation was smaller. Plaintiffs do not claim they sustained any loss in future career prospects. Plaintiffs do not claim they suffered emotional harm such as depression or sought counseling. Evidence of damages sustained by plaintiffs is sparse. Here, plaintiffs fail to present evidence as to how many people read defendants' defamatory statements, and the evidence clearly indicates the audience of those who did read it is substantially less than the audience in prior case law. So, while in prior case law, there was a wider audience, here, the evidence indicates that whatever the amount of people that did read it, which is vague, whatever that number is much less than the supporting award in a different case, so therefore the damages should be less, is the idea. Upon consideration of the aforementioned evidence presented to the jury in similar cases, as well as the importance of respecting the province of the jury as to act as fact finder and jury's discretion to award a reasonable amount of damages, the court remits, which is to say lessens, the compensatory damages as we previously discussed. So, the way this sort of reduction works is that in the words of the court order, a new trial and damages will be held unless they accept reduction damages. So the judge has said, here's how much damages you get. If you accept it, then great. And if not, we can do a new trial and try again. So it's up to you. Which way do you want to go? So we'll see how that goes. So. $19.99 from Just Me says on the Texas electric car tax, if everyone to stop using all vehicles and just started walking everywhere, the state would pass a sideway tax. The old state saying only thing for sure is death and taxes unless you're a Biden. Cute. Yeah, they very well might pass a sideway tax, which, if everyone started using the sidewalks a lot more, to be fair, a sidewalk tax wouldn't even be unfair in such a situation. If everyone stopped using cars and everyone started walking a lot more, then, walking also causes wear to sidewalks. So yeah, they would have to the amount of maintenance that would be required for sidewalks would go way up. So yeah, the government would have to pass some kind of sidewalk tax, because the sidewalks need more repair. So yeah, so it's not even ridiculous. But yeah, your super chat is appreciated. Thus, that brings us to the end of this Renaissance Fair libel case in which the king and queen of the Renaissance Fair were accused of all kinds of vile and nasty things by a woman without apparently any basis as determined by the jury. The jury said, how about $1.4 million? The court says, how about $71,000? Because although there are damages, not that much in the judgment of the court. The court thinks not more than that. So they can either accept that amount or they can go back to trial and try again, and we can do another case. So which way they will go, who knows? We will see. Of course, they could also appeal the remitter as being unduly low. So you can either do a do-over on damages, accept the amount, or appeal. So which of those options will you do? We will see. But at least for the moment, that brings us to the end of the discussion of this case. Did you like that one? A little bit deeper dive today? I thought it was an interesting case. Push the button. Thank you. Excellent. I had a good day at the gym. I think it was yesterday. I did some chest fly. I did some reverse fly, working on my delt. I did some bench press machine. I think I was doing like 170 or 180, like for 3 reps on the machine. I'd have to check my log for the exact number. It needs to go up. I'd love to hit 405 on the bench, on a proper bench press. I'd love to hit 405 for at least 1 rep, preferably 4 reps, or preferably 4 multiple reps. If I could do 5 reps, that'd be cool. So we're a long way from that goal. We're a long way from that goal. If I'm doing like 3 reps at like 180 on the machine, we're a long way from like 5 reps at 405 on the bar. But, hey, we're making progress. Anyways, also did some lat pull down yesterday. That was good. And what else did I do yesterday? That was good. I did some back extension machine, which I continue to crush the absolute shit out of. I did some squat yesterday. I think I was doing 180 or 200 squat yesterday for reps. It was a good day. It was a good day. Rowan asks in chat, am I following any particular program? No, not really. I'm using this app called Fitbod, and it's an AI app, and it just tells me what to do. So I do what the bot tells me to do. I have absolutely given myself over to the AI overlords. When it comes to the weight loss and weight journey, yeah. The AI overlords know all. Sandy gifts 50 gift memberships. That's very, very generous, Sandy. Thank you very much for your 50 gift memberships. That's very, very thoughtful. Sandy is a fantastic mod as well, and I appreciate her continuing support of the channel. And it's great. All right, let's do another. Let's do this case, I guess. I got a lot of stuff today on today's docket. When do I edit these things is the real question. Did she gift you a smile? Sandy always gets me to smile. But 50 gift memberships does mean Callie, right? Because that was our new deal. Hi, Sandy. I'm Callie the Beef Fish. Thank you, Sandy, for the 50 gift memberships. Wow. That was amazing. That was amazeballs. I really like the 50 gift membership. Thank you, Sandy, very much for your continuing support of the channel and for being a fantastic moderator and allowing me to live my best bee fish life. Because of you, Uncivil Law might actually give me some fish food now. I've been hungry for a while. He doesn't feed me. I don't like it very much. But maybe he'll give me food now. Yay, I'm Guy the Bee Fish. Yay! All right. In parental rights in education news, the state of North Carolina is following somewhat in the stead of Florida by saying that parents have a right when it comes to the rearing of their children, which is, a concept so basic that, it was just a built-in concept. But for some reason, in modern education times, it's thought that, the schools have the right to fundamentally parent the children over the rights of the parents, incidentally, which seems very odd. So North Carolina has passed a law similar to Florida, which says, you know what? Parents have the right to parent their children in the first instance. Wow. And the school has to respect the right of the parent to parent. Wow. So let's learn a little bit more about this North Carolina parental rights law in education. Let's get started with this. As students around the state prepare to return next week for the start of the school year, which incidentally some schools have already started, despite the fact it's in conflict with state law, which we covered in a various previous states. So state law says when the start of the school years, and some school districts are like, no, it's not. So yes, next week the school year's supposed to start, but some kids are already in school because that's a fight. Teachers are also trying to figure out what they need to do with comply with the newly enacted Parental Bill of Rights, which says that parents might have the right to rear their own children in the first instance. Wow. Republican lawmakers were so pissed over this, they managed to override the Democratic governor's veto. So the Democrat governor's like, I don't believe in rights of the children, but the Republican legislature's like, we do. Screw you, and managed to overrule their veto. So all but one section takes effect immediately, leaving teachers little time to adjust lesson plans or change classroom materials. So, it's like it was set to go into effect for the school year. So it's like, figure it out. It's the law now. The law forbids any instruction or discussion of sexual orientation or gender identity in kindergarten through fourth grade. Wow. Maybe no sexual orientation or gender identity talk in the elementary school. What an amazing burden on the school. And it requires school to get parental consent before allowing a child to use a different name, pronouns, or identifying themselves other than their gender at birth. Wow. So parents have the right to, raise their own children, and the child wants to use a different name. How about we get the parents say so on it first? What a deep concept. Amazing. Thank you for the gift memberships, Leela Quinones. That is very thoughtful as well. We appreciate that as well. And your 10 gift memberships is extensively appreciated. Thank you. It also requires the district to more. Okay. It also requires districts to more fully inform parents about how to object to materials or curriculum topics, how to file formal complaints, and how to opt their students out of surveys on topics that parents might find appropriate. So, hey, parents get the right to control their kids' education, not the schools. It's amazing. Local school boards will have to meet and approve policies to implement the new law, which will take some time, but the law is in effect now, and teachers could be disciplined if they violate it now. Because the law, amazingly, overcomes and supersedes local school boards. See, that's in the nature of the hierarchy, right? The state is in control of the local school board. So the local school board's like, we have our own policy. And the state's over here like, that's fun. I have better policies. So follow my policies or else. Supporters of the law say it was needed to safeguard children. Sponsors say they heard from parents who faced difficulty getting schools to give them information about children and what their students were learning. So some parents were having trouble getting the teachers to give over the curriculum. Which, why would the teachers have any problem giving over the curriculum? Should be available for the parents. But no, no, no. Some teachers are not about that. And the state's like, you are now. Tamika Walker Kelly, who's the president of the North Carolina Association of Educators, who's the state's largest teachers group, says most of the parental rights enumerated in the law have already been law for years. Well, fantastic. Then you won't have to make any changes. Right? If it's already been the law for years, then there's no harm, no foul. Right? If the legislature just is acting in a law that requires you to do the same thing you did before, then why are you complaining? Saying, quote, this is not an effort to increase the effectiveness of school or actually grant parents any more rights. Unfortunately, we've seen this culture war as the partisan politics insert itself into school functioning. But what's the problem? If it doesn't actually grant parents any more rights, if it doesn't actually change the scope, then in what ways are the partisan politics inserting themselves into school? Because it doesn't matter. So does it matter or doesn't it? Right? Does it matter or doesn't it? If these are rights they've already had, then how are the partisan politics inserting them schools into the school? They're not. Because nothing changed. Or did it? Which way do you want this thing? We're seeing a piece of legislation that was intended to create a divide between educators and parents, to seem as if educators and parents are not working together to ensure academic and overall success. Well, the concern was that you maybe weren't working together. This concern was specifically that, that the educators were trying to supersede the parental role of the parents. So, yeah. They say teachers are most concerned with the effect of the new law that will have on the LGBTQ plus minus divided by sign ampersand squiggly mark question mark upside down question mark students, especially the provision that requires schools to inform parents if a school is questioning about their own gender, because hey, maybe a parent has the right to know if their own child is saying something about their own gender. We know that not everyone who comes to us at a school has a caring adult. Sometimes the educator or school personnel is the caring adult. Yes, we know better than the parents. They don't have a caring adult. How do we determine if it's a caring adult? Whether they believe in what we believe in. That makes them caring or not. It's our responsibility, part of our professional standards and code of ethics, to think first about the priority of student, their health and safety, as opposed to the parents who have a right to, raise their own kids. We'll continue to navigate that as educators, but the provision in the law does make that a lot more difficult. It's also likely to be time and resource intensive for school districts. During the veto override debate, the representative Laura Budd said the law will require school districts to create or modify 20 different school policies, regulations, and operational guidelines. But I thought they weren't making any changes. I thought these laws and rights were already in effect. What are you talking about? What do you mean they have to make changes? I thought the laws were already in effect and have been for years. What do you mean you have to make changes? Lol. It will take hours and hours of meetings. Oh my God, teachers have to do meetings. Wow. Those meetings are time that's going to be spent by the school officials and the Board of Education, so they could be spent in compliance with the law instead of spending that time recruiting, training, and putting a living, breathing teacher inside every classroom who will teach the indoctrination that we want to teach. That last part was unspoken, but yeah. Earlier this year, legislative leaders had discussed the lane start of the law to give time to districts to implement, but the change didn't happen before the veto override, so not so much. The House Speaker, who supports the new law, says they haven't heard any complaints about it from his local district and doesn't expect implementation to be difficult. It's really common sense law, the House Speaker said. It's something that so many of us think should have been done already, letting parents have these decisions, to have information about their own child's education. So it's the law and I expect them to follow it. Wake County Public School System spokeswoman said attorneys in the state are currently reviewing the new law and expect to issue guidance real soon. I'm sure they are. Thus, that brings us to the end of the story for the moment about the North Carolina school year that is joining the state of Florida and other states. And how about less with the wokeness? And also, how about parents have a right to raise their own children? That would be good. And how about if the kid is going to gender transition, maybe the parent should be aware of that, as the parent of the child. Wow, deep and amazing thoughts. So they're not quite sure how they're going to comply with this law, even though it's already been the law for years and there should be no problem because nothing has changed. Or has things changed? I don't know. But that is now the law in North Carolina, Florida, and some other states. And so let's learn a little bit. And so for at least the moment, that brings us to the end of discussion of this story. Doesn't matter what I say. As long as I say it with inflection, makes you feel I'm going to. Hey. Some deeper truth or deep reflection. But I said nothing so far. I can keep it up as long as it takes. Doesn't matter who you are. If I'm doing my job, it's your resolve that breaks, 'cause the hook brings you back. I ain't telling you no lie. The hook brings you back. On this you can rely. 9.99 from Just Me. One of these days, I'd love for you to go over the case of O'Hare versus Texas and change local versus federal control from that point forward. Okay, I'll add that to the potential list. Thank you very much for your super chat and your contribution as well. All right, do we want to cover this longer case? Yeah, I kind of do. Whatever. This is not United States of whatever. And this is my United States of whatever. I was out with the beach with Coco looking at this woman. She's like, and I'm like, whatever. My United States of whatever. All right, let's cover this one. In continuing follow-up to the cases of Masterpiece Cake and 303 Creative, a case involving a farmer's market that refused to host a same-sex wedding on its land that violates the free exercise clause. So we're going to learn a bit more. All right, I need to redo that intro. I need to redo the intro. Let me try again. Miller hats. I don't know anything about Miller hats. I'm not sure Miller makes a hat big enough for me. Do they make hats big enough for me? Probably not. Show all cowboy hats. Do they make hats that are big enough? Sort by, I need large hat. Doc cowboy hat. Yeah, they don't make hats big enough for me. Miller hats is not going to do the trick. That's the hat store you went to in Texas with vices. I've never been to a hat store with vices of any description. Aussie Overlord went with vices to a hat store. I didn't. All right. In Masterpiece Cake and 303 Creative News, people are still being discriminated on the basis of the fact that they don't want to host certain things that offend their sensibilities, and the government is trying to force them to. In this case, this deals with a farmer's market. So there's a farmer's market, and there's a person who would like to have a spot at the farmer's market. This particular person hosts weddings, but they won't host same-sex weddings. So the farmer market is all like, nah, you can't come over there. And the court's like, yeah, you will, because you can't discriminate on the basis of their religious beliefs. So let's learn a little bit more about this farmer market conflict. Let's get started with this. You went with Runkle? No. Runkle and I went to Calvier's boot shop. We didn't go to Miller's. And also, this hat isn't from any of those places. The hat is custom made. From the case of County Mill Farms versus the City of East Landing, the City of East Landing requires vendors for its farmers market to comply with the city's public policy against discrimination. So the city has a farmers market. It's a governmental farmers market. And if you want to have a space at the government's farmer market, you have to comply with the city's demands. The County Mill Farms, who wants to have a spot, offers to rent a portion of its property, which is not connected with the farm market itself, for weddings. So County Mill Farms is a private farm, and it has a space, and it will offer people the spot for the weddings. That's one of the things they will do. However, they won't rent the property for same-sex weddings. So the farm has the weddings, but not for the same sex. They want a space at the farmer's market because they're a farm. And the farmer's market, which is controlled by the city, is all like, nah. Because of this business practice, the city denied the County Mills Farm vendor application for 2017, and therefore they sued. All right? So you got the idea, right? The farm has property that isn't where the farmer market is. That's not where the farmer market's held. That farmer market's held somewhere else. But they have property in which they will host weddings, but not same-sex weddings. They want a space at the farmer's market because they're a farm and they'd like to have a space at the farmer's market. But the city's all like, nah, because you don't allow the same-sex weddings, okay? And thus the conflict is set up. Was that unduly repetitive, by the way? This is one of the continuing struggles I have sometimes with things on the channel. It's like, is it unduly repetitive? Because I think I just explained that 3 different times. But I wanted to make sure that people understood it with the different players in point. Was it unduly repetitive? Sometimes I can't tell if I'm like repeating myself too much. Am I repeating myself too much now? Is this too much? Am I repeating myself? I'm getting an existential in my head. Yeah. Runkle did get his hat with me. Runkle did get his hat when he was with me. But I didn't get my hat when I was with him. We bought our hats at different times. Runkle was not with me when I bought my hat. I was with him when he bought his hat at 2 different stores. Yeah. Because Runkle has a normal size head, so he can go to a normal size store. All right. Defendant relied in the revised 2017 vendor guidelines to deny the application to participate in the farmer markets. The stated reason for denial was the decision not to rent venues for same-sex weddings. Plaintiff's decision was motivated by his religious beliefs. So he says the reason I'm doing it is freedom of religion. Therefore, plaintiff says they refuse to choose between their religious belief and governmental benefits to which they should be eligible. So the government is the one denying them, and they're denying them on the basis of religion. So that's the problem. The court acknowledges that neutral and generally applicable policies don't violate free exercise clause. I'm dying. I'm dying. Goodbye, cruel world. The court acknowledged that neutral and generally applicable policies do not violate the free exercise clause, but holds the city's policy wasn't neutral and generally applicable. So we've discussed this before, most notably in the U.S. Supreme Court case called Smith, right? There's this idea that you don't have to treat religion necessarily better. You can, but you can't treat it worse than its secular counterparts. So if it's neutral and generally applicable, you're probably okay, right? So if everyone is treated exactly the same, regardless of religion, then you're not discriminating on the basis of religion because it's neutral and generally applicable. Everyone's treated exactly the same, regardless of their religion, right? So regardless of your religious beliefs, everyone's the same. But in this case, that's not actually the fact because there are exemptions. So it's not neutral and generally applicable because you have carved outs. So the court writes, a law is not generally applicable if it invites the government to consider particular reasons for a person's conduct, providing a mechanism for individualized exemptions. So it's like, yeah, you can't discriminate unless we say you can, and now you have a problem again. Where the state extends discretionary exemptions to a policy, it must grant exemptions for cases of religious hardship or present compelling reasons not to do so. So if you extend discretionary exemptions, you must provide the exemption of religion. You don't have to provide any exemptions at all, right? You don't have to provide any exemptions, but if you do, religion has to be one of them because freedom of religion. It is a mechanism for exercising discretion and granting the exemption, not the existence of an objectively defined exemption that undermines the general applicability. So if this policy were uniform, fine, but you allow exemptions, your decision to allow exemptions, but you won't allow their exemption, and that's a problem. You can't do that because suddenly at that point you're treating religion worse. You will allow exemptions for other reasons, but not religious reasons. Now you're treating religion worse, and you can't do that. See, for example, Smith, or their citation of Fulton versus City of Philadelphia, which basically stands for the same proposition. The 2017 vendor guidelines allow for the exercise of discretion at least two ways. Discretion that undermines general applicability. First, the guidelines allow for discretion when selecting vendors for invitation and approval of annual vendor applications. The relevant rules distinguish between annual vendors and invited vendors. To be considered for an invitation, a vendor must have consistently adhered to vendor guidelines and embody the spirit of the market, which I'm not even sure what that means, but okay. The paragraph also sets forth the vendor must exhibit to embody the spirit of the market, so I guess they define that. So they'll tell you what it means to embody the spirit of the market, which I guess is something. Multiple factors that affect the success of every vendor are considered. So apparently these are the factors that speak to the success of the market. Merit high quality produce and presentation, convincing amounts of produce. I'm not sure what it makes an amount convincing, but okay. Attending the market each and every week, offering a diversity of fresh produce, creating an inviting atmosphere for consumers, displaying products in a thoughtful and creative way. That is, use of tablecloths, unique signage, three-dimensional displays. I think that really should be EG rather than IE, but I'm not sure if they know the difference, but okay. Pricing products fairly, being friendly and courteous to and interacting with consumers, building a relationship with customers, participating in market initiatives and special events, adhering to marketing guidelines including attendance, parking, safe food handling, signage, etc., following the MDA guidelines for providing safe food samples, complying with the City of East Landing Civil Rights Ordinance and public policy against discrimination as contained in Chapter 22 of the East Landing Code while at the farmer market, and also having fun. So apparently having fun is a separate criteria, I guess, unto itself. That's nice. Subsection M allows for the Planning Commission to consider whether a vendor discriminates as part of the vendor's general business practices. During testimony at trial, Heather Magino, who was the marketing manager in 2016 and 2017, agreed that the Planning Committee examines these factors on a case-by-case basis to determine whether to invite or not invite a vendor. Magino agrees that the Planning Committee should not decide to invite someone because he or she was grumpy and did not have a colorful display. George Landens, the city manager, acknowledges the guidelines do not include any indication about how to weigh the different factors, including subsection M. He testified that he would weigh subsection M as a yes or no thing. This functionally unfettered discretion means that the vendor guidelines are not generally applicable and function as a mechanism. So yeah, so you have set up some rules and policies, and one of them deals with your compliance with the city code, and you didn't give exemptions because you gave exemptions otherwise. Secondly, and perhaps most importantly, the vendor guidelines give the market manager discretion to either enforce or not enforce the guidelines. Uh-oh. Uh-oh. So the guidelines themselves may or may not be the problem. I can probably get past the guidelines being the problem. But when you give someone discretion to enforce or not enforce the guidelines, that's where you go, uh-oh. Because when you say, you have discretion as to whether to enforce the guidelines at all, what does that suggest? Arbitrary and capricious. Arbitrary and capricious, right? If we were just following a set of guidelines and we had to follow the guidelines and it produced a result, then maybe that would be okay. But when we give someone the power to completely ignore the guidelines completely, arbitrary and capricious, now we have a different problem. Paragraph 15 of the vendor guidelines, which sets forth the marketing manager responsibility, gives the manager authority to deny or remove vendors from the market, impose disciplinary action, and grant exemptions and accommodation on an individual basis. Uh-oh. Right. So now we've given the power to do whatever the hell we want. And that sounds a lot like we're running our own little fiefdom over here. And that is a problem when it comes to governmental action. They can't run their own little fiefdom. Arbitrary and capricious is bad. So anytime you say arbitrary and capricious, you have a problem. The enforcement discretion constitutes a mechanism for individualized exemption, not fundamentally different from policy in the case law. And mere existence of the mechanism, not its exercise, renders the policy not generally applicable. So even if they never used this king-like power, the fact that they have the king-like power is a problem. Because they have discretion whether or not to use the discretion in an arbitrary and capricious way. So like, I'm never going to use my discretion. It's like, well, but you have it though, and it's arbitrary. So yeah. The court also concluded the policy wasn't neutral or generally applicable because it concerns exemptions for certain secular reasons. Even more right? So at this point, if we're going to treat the religion worse than the secular, we have many problems under Smith. A law lacks general applicability if it prohibits religious conduct while permitting secular conduct that undermines the government's asserted interest in a similar way. Citing Fulton. You could cite Smith. Either one will be fine. Under the Free Exercise Clause, the government cannot, in a selective manner, impose burdens only on conduct motivated by religious belief, while failing to prohibit non-religious conduct that undermines the interests protected by law. Yep, you got to treat the religion on the same terms, and you can't treat the religion worse. A law burdening religious practice that is not neutral or not generally applicable is subject to strict scrutiny, and good effing luck with that. To meet strict scrutiny analysis, the government cannot rely on a general interest advanced through enforcement of law. It must show a compelling interest in exactly this specific exemption, which not so much. Chapter 22 of the Code, incorporated into the vendor guidelines, is not generally applicable because it permits secular conduct through exemptions while prohibiting the same conduct motivated by religion, which you can't do. The entire chapter prohibiting discrimination does not apply to private clubs or other establishments that are not open to the public. Chapter 22 also provides provisions that allow for discretionary exemptions. For example, discretion to grant employment exemptions on a bona fide occupational qualification. For a city contract that contains covenants, the contractor will not discriminate against an employee. The city's discretion to declare whether the breach of covenant is material breach or not, which makes it discretionary, which makes it arbitrary, which is a problem. Chapter 22 contains specific non-discriminatory provisions concerning spousal benefits. It prohibits the city from contracting with contractors that discriminate on the basis of marital status and sexual orientation. By failing to provide employment benefits for employees with domestic partners, the contractor would otherwise provide for of a spouse of a married couple. So if you have the domestic partners, that's A-OK by the city. Chapter 22 contains objective non-discriminatory exemptions and also contains discretionary exemptions. In subsection B, a city must include a non-discriminatory covenant concerning the benefits in any contract, and the city has discretion to declare a breach of the covenant as a material breach. Subsection C contains a list of 8 objective non-discriminatory exemptions, including exemption for any contract less than $20,000. Uh-oh. Yeah, why is $20,000 a magical number is a good question. The objective non-discriminatory exemptions make the city ordinance not generally applicable. Yep, sounds like it to me. We have lots of discretion all over the place, and we're not going to exercise it for the religion when we exercise it for these other reasons. Yeah, you can't do that. The city relies on a general justification of its non-discrimination policy, its desire to address discrimination on the basis of sexual orientation. Defendants' non-discrimination orients, however, contains multiple objective exemptions and discretionary exemptions, all of which will allow the city to do business with an entity that does discriminate on the basis of sexual orientation. So they will do business with cities, with businesses that discriminate only on their terms, which that's the problem. Defendants not offered any particular justification for enforcing their non-discriminant ordinance against the plaintiff, nor is defendant explained why it declines to offer plaintiffs the exemption from the non-discrimination ordinance where the ordinance provides an objective and discriminatory exemption to other business entities. Thus, that brings us to the end of this case dealing with a farmer market that is run by the city. The city has a farmer's market that it offers to the farmers who might want to come and sell their goods at the farmer's market, as one does. A particular farm in question has some property that they will rent out for the weddings, but not the same-sex weddings because it defends their religion. The city's like, okay, you can't have a space at our farmer's market because you don't allow the same-sex weddings. The problem being in part that they are discriminating on the basis of religion because they have all kinds of exemptions for all kinds of things, all kinds of secular reasons. And also, the manager just has unilateral discretion to just ignore anything at any time based on apparently their whim, which makes it arbitrary and capricious. And anytime the government's acting arbitrary and capriciously, that is a problem, because that's pretty much something the government can never do. It's just act arbitrary and capriciously, especially when it's acting arbitrary and capriciously in a way that's hostile to religion, or at least not accommodating of religion in the same way it's accommodating of other things. That's a real problem. So yeah, that's all a problem. And so the city must host this farm just because it would allow other people to come on equal terms, and it can't discriminate on that basis. So farmer market for all, and that brings us to the end of discussion of this case. Push the button. All right, let's see what else we got. All right. In workplace discrimination news, a U.S. appeals court, namely the Fifth Circuit Court of Appeals that governs Texas, among other states, has adopted a revised rule that makes it easier for people to prove workplace bias claims. So they have abandoned a rule that made it more difficult for these claims and says, okay, now we're going to make it easier to show these workplace bias claims. So let's learn a little bit more about this case. The en banc Fifth Circuit Court of Appeals on Friday revived a lawsuit claiming that Dallas County, Texas, required female jail guards, but not men, to work at least one day each weekend, and therefore overruled a long-standing precedent that federal anti-discrimination law only prohibits bias in ultimate employment decisions, such as hiring, promotion, and settling pay. So this was a issue that the Fifth Circuit said before, okay, we only think discrimination on the basis of sex applies to ultimate employment decisions, which, doesn't make sense compared to the Civil Rights Act. So the Fifth Circuit said, okay, yeah, we've been wrong all this time, which they were. The precedent had imposed a more strict standard than Title VII of the Civil Rights Act itself, which applies to any terms, condition, or privilege of employment. It's no wonder that no other court of appeals applies so narrow a concept, the Fifth Circuit wrote. So yeah, the Fifth Circuit basically have been screwing this up for decades. Title VII says you can't discriminate as relates to any term, condition, or privilege of employment. So that isn't just the decision as to whether or not to hire. That isn't just the decision as to whether or not to fire. That isn't just the decision as to whether or not to promote. That isn't just the decision as to whether or not to pay. That is every decision. That is all the decisions. It is all the things. Any term, any condition, any privileged benefit of employment, anything. You can't discriminate on the basis of sex. So if you want to say that, women have to work 1 day a week, then, then men also have to work 1 day or 1 day a weekend. If you say women must work 1 day a weekend, then men must work 1 day a weekend. Unless you can point to a specific reason that you're discriminating on the basis of sex. So maybe you can point to a bona fide occupational reason, right? So maybe you can get past this, maybe. But, in the first instance, you have to be equal as it relates to sex, which is fair enough. And the circuit has just recognized this apparently for the first time, just having discovered this is law, which it clearly was. The lawyer for the plaintiff says the ruling makes clear that Title VII prohibits to any workplace discrimination, which it does by its own terms. The Dallas County District Attorney's Office did not immediately respond to comment because they lost. The 9 female correctional officers who sued Dallas County were backed by the U.S. Department of Justice, which filed an amicus brief. The Department of Justice urged the Fifth Circuit to adopt the rule that will apply to any terms and conditions because that's what the federal law says. I mean, this is just a straight reading of the law, guys. I mean, I don't know what the Fifth Circuit, why it had a bug up its ass, because it just clearly says that in the text. Yeah, any term of condition of employment. Yeah, you can't discriminate on the basis of sex. If you want to discriminate on the basis of sex, you're going to have to prove that you have a reason. You can't just do it for the hell of it. Dallas County had acknowledged it as a sex-based scheduling policy for jail guards, but maintained scheduling is not an ultimate employment decision, which, it's not. So Dallas County's like, yes, we were discriminating on the basis of sex, but it doesn't matter because we weren't trying to fire them. And the Fifth Circuit's like, yeah. The 3-judge panel of the Fifth Circuit, of course, affirmed the case law because they had no choice, but said the Fifth Circuit should overrule them, and then did. So the Fifth Circuit Court of Appeals is like, this is really, really dumb, but we have no choice. We have to do this because it's the precedent of our circuit, and we can't overrule the precedent of our circuit. So we are unfortunately required to say that, yeah, Dallas is right, and we think that's really dumb, and we really think the en banc should reverse this, and now they have. So great. On Friday, the Circuit Judge Edith Jones, in a concurring opinion, said it was unnecessary to overrule the court standard for approving the claims because Dallas County had admitted the scheduling policy was based on sex. Well, no, that's not the issue. The issue isn't, are we discriminating on the basis of sex? Apparently, the issue was, are we discriminating on the basis of sex in a way that matters? And apparently, we had determined it didn't matter, which was really dumb. Also saying that the ruling failed to be the precise level of minimum workplace harm they must allege. The majority's incomplete ruling leaves the bench bar and employers no clue as to what this court will finally decide as the minimum standard for Title VII liability. Well, I mean, the statute itself says pretty clearly, any workplace benefit, any of them. So the injury can be slight if it's on the basis of sex. So what's the minimum standard? I don't know, $1? De minimis harm? You can't discriminate on the basis of sex and any condition of employment. Unless there's a bona fide occupational reason, which there might be, but you have to actually, show that. So if you have a bona fide occupational reason, then great. If not, then not so much. Thus, that brings us to the end of this case by the en banc Fifth Circuit, which just, read the law, which it clearly says in Title VII, you can't discriminate on the basis of sex and any term or condition of employment, which, means all of them. Any sort of benefit, any sort of program, any sort of anything. You can't discriminate on the basis of sex unless you have a bona fide occupational qualification. So there are some things that you might be able to discriminate because only men or women can do that job, which, fair enough. Like, if you want to say that only women conduct the women's strip searches or only men conduct the men's strip searches, then cool, right? That makes sense. As a bona fide occupational qualification, only women can do this particular job because of the reason I just said just now. That would be fine. And so if you can show that a reason that's a bona fide occupational qualification, then cool. Then you might be able to discriminate, but you can't discriminate just, for the hell of it. So here they're like, how about women work the weekend? but men don't. And they're like, that's really dumb. Why do women have to work the weekend and men don't? And Dallas is all over here like, it doesn't matter. We can discriminate all we want. Duh, 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 duh. And Fifth Circuit's like, no, you can't. And then some judges on the en banc are like, well, where does it stop? And I'm like, well, it stops when you stop discriminating on the basis of sex other than in a bona fide occupational qualification. I mean, just follow the statute, man. So where is the bare minimum? I don't know. If you do anything, if you make the women stay, I don't know, 5 seconds longer than the men because they're women, then, don't do that. You do it because they're women. You're not allowed to do that either. The women must stay 5 seconds longer. Why? Because they're women. Oh, it's so minimal. It doesn't matter. It matters. You can't do that. So yeah, that reverses a long, stupid ruling of the Fifth Circuit. So discrimination on the basis of sex continues to be illegal. And that, for the moment, brings us an end to discussion of this story. All right. Excuse me. All right. Sergeant Hayes is loving the show today. I'm glad you're loving the show today. We did some deep dive legal analysis today. Yeah, we did some deep dive legal analysis today. We did two legal cases in full, and we did some deep dive legal analysis. We did some good stuff. We get along over here on Uncivil Law. We do some good stuff. All right, time for Florida Man, and then we'll sign off. And then I guess I got to do editing, and probably need to go to the gym today. I'm a disaster area. I'm a disaster. My teeth. I need to clean my teeth. Did I push the button? If not, I'll push it again. All right. Great. All right, let's cover Florida Man and wrap this thing up. For today's Florida Man story, we take ourselves to a Florida pastor that turned out to be the leader of a crime ring that stole $1.4 million of goods from Home Depot. So apparently didn't get to the part of the Bible about not stealing, I guess, because he's like, I'd like to do the stealing. I'd like to run the crime ring as the pastor and steal $1.4 million of goods from the Home Depot. Well, we will make sure that he gets a new home that is constructed of only the best materials. Let's get started with this. A Pinellas County pastor in Florida, his wife and others are accused of stealing $1.4 million worth of goods from Home Depot stores across the state of Florida and reselling those goods on the eBay. Doing a little bit of theft, doing a little bit of the eBay. Robert Dell, who is 56, also apparently forced vulnerable people to take part in the scheme, according to the Florida Attorney General. The news release from the office says that Dell is a pastor at The Rock Church in St. Petersburg and founder of a halfway house serving people recovery from drug addiction. How nice. So he gets people who are perhaps vulnerable and in a space to be susceptible because he runs a halfway house. How nice. Where will he find his criminals? Oh, that's right. They're right over there. But in a note on the homepage, the Rock Church claims that Dell hasn't been a pastor there for more than 2 years. So the Rock is trying to distance itself and saying, well, Dell isn't part of the Rock anymore. But maybe he'll be part of the Rock in the future. Although we closed that prison down. That would be Alcatraz, by the way. So yeah, I don't know whether or not we're trying to reenact the movie The Rock or something, but maybe we can reopen Alcatraz just for him. I mean, it is a nice prison right there in the San Francisco Bay. Why not reopen it? That'd be great. The news release names four other people as co-conspirators in the case: Jacqueline Dell, who is Robert Dell's wife; Karen Dell, who is Robert Dell's mother; Jessica Wild; and Daniel Mace. Robert Dell, Jacqueline Dell, Catherine Dell were arrested August the 1st after officers with the Office of Agricultural Law Enforcement executed a search warrant. I mean, that's just funny because why the Office of Agricultural Law Enforcement, right? Of all the law enforcement agencies, that could be the one that conducts the bust into the Home Depot theft ring for the eBay. Of all the law enforcement agencies, the one that conducts the bust is the Office of Agricultural Law Enforcement. How the hell did that happen? I don't know. But apparently they're the ones that are conducting the bust and executed the warrant on Robert Dell's house in St. Petersburg. He's charged with racketeering, conspiracy to commit racketeering, and dealing in stolen property as the organizer of the racket. So he is the mafia boss. Pastor by day, mafia boss by night. How exciting. Jacqueline Dell was arrested on a charge of conspiracy to commit racketeering, and Karen Dell, who is Karening it all up over here, on a charge of dealing in stolen property for the moment. Mace of Tampa was arrested Wednesday on charges of racketeering and conspiracy to commit racketeering. Wild's booking and charge information was not available at press time. According to the Attorney General's office, the group shoplifted in Milwaukee. Milwaukee, DeWalt, and other branded products from Home Depot stores in Citrus, Hillsborough, Manatee, Pasco, Pinellas, Polk, and Sarasota counties, getting their work on over the great state of Florida. Mace and Wild stole the majority of merchandise on an average victimized stores 5 to 6 times a day. Damn. They're getting around, man. Just going in and out of that Home Depot over and over and over again. And amazingly, it finally caught up with them. The pair then delivered the products to Robert Dell, who sold them on eBay on a storefront named Anointed Liquidator. Wow. Anointed Liquidator. Wow. Anointed by God. Wow. I'm not sure God wants you to liquidate the property of others. I seem to remember something in the Ten Commandments vaguely about this, but he thinks he's been anointed for the liquidation, so I'm not sure how that works. Okay. According to the investigation, Dell demanded the crimes under the threat of abuse and used positions of being a pastor and founder of the Halfway House to manipulate others to participate in the criminal scheme. Home Depot suspects Robert Dell operated the scheme for more than 10 years and thinks the company has lost more than $5 million worth of property as a result of this scheme. Holy shit, dude. I guess this was one organized ring, right? $5 million the company thinks has been lost. So far, $1.5 million accounted for, $3.5 million left to go. Pinellas count records show the judge sealed warrants and other documents related to the case at the request of the prosecutors. In 2019, police arrested Wild and Mace on grand theft charges for attempting to take nearly $4,500 worth of hardware batteries from the Clearwater Home Depot, according to the arrest affidavit. The pair placed the batteries inside a bin, closed the lid, and attempted to exit the store when one of them became scared and spooked after spotting a loss prevention officer. The two left the merchandise by the door and exited the store. So we have previously come into play with these people, so we have some evidence they might have been involved on a routine basis. Thus, that brings us to the end of the story for the moment about the Pinellas pastor that led the ring into the stolen goods. $1.4 million officials say. Home Depot says it's more like $5 million, apparently as part of this pastor ring. So very exciting. So we are going to arrest all these people and try to take their money and seize some of it and I guess repay at least Home Depot in part. So very, very exciting over here. So I guess go forth and sin no more. At least for the moment. That makes the end of this story. Fantastic. What good times we've had together today. What good times we've had today. You've sent me gift. Oh, that's always nice. Let's see what we've got. Who wants what and why? All right, Sandy. Let's see. What gift and memberships did we have today? Jules Buddha gifted 20 gift memberships. Veronica's been a member for 6 months. Hera Hart, member for 28 months. Thank you for hitting that beautiful, beautiful join button. Alan Parker gifts 20 gift memberships. Rosie 1 joined the $5.99 uncivilian tier. So a civilian, an uncivilian with a greater devotion to this channel. Instead of being a 99-cent a month uncivilian, she joins for $5.99 a month. So she loves me 6 times more than the rest of you lot. So someone to pay attention to. Nicola Maxwell has been a member for, I think, 6 months. I can't quite read it in the thing, but I'll say 6. And QS been a member for 24 months. Just Me, member for 4 months. On the BLM decision, the parents should have had Madeline Murray O'Hare's attorneys, and on the Texas decision. Just Me said on the Texas elect car tax, if everyone decided to stop using vehicles and started walking everywhere, the state would pass a sideway tax. We discussed that. Angie Torres gifted 10 memberships. Leela Quinos gifted 10 memberships. Just Me gifted $9.99 to ask me to cover O'Hare versus Texas. And that is the end of the super chats for today. Excellent. All good stuff. Everything is awesome. Everything is cool when you move to the beat. Everything is awesome when you're part of the team. So, all that's good stuff. Let's see. Who's streaming? Is anyone streaming that I can kick you over to? Let's see. Let's see. Who is streaming? Recovery Addict is streaming, and Charlotte on the web. I'll kick you over to Recovery Addict. I'll kick you over to Recovery Addict. He's covering the Black Widow murder trial. So you can go watch that stuff, I guess, and check out his channel and see if you like that. For the Black Widow murder retrial. He's on day 7, part 2, and day 8, part 1. So if you want to go check that out, I guess we'll kick you over that way. Yeah. All right. I'll kick you over that way. And at least for the moment, that'll bring us to the end of the stream. And I hope you have a great day. Let's see. Where's my end stream button? I know it's around here somewhere.